Well, I hope you forgive the long pause. I have to say, because we were just waiting for people to join. I have to say, it felt like one of those sort of "Who wants to be a millionaire" questions, or one of those things. And the winner is, and then we have that long pause while people get excited as to who the winner is. But thank you for joining us. Good morning and welcome to our Think House Spring program for 2021. I don't know about you, but after the long, dark lockdown days of the last couple of months, it feels really good to be waking up in the light and seeing the sunshine and the flowers coming through. Um, this is the last of our series of 4 ThinkHouse webinars for spring. So far, we've looked at employment issues in the post-COVID world. We've looked at data sharing and also customs and trade post-Brexit. And if you'd like to see these events, please feel free to download our recorded podcasts. It's probably fair to say that when we ran our Spring Think House program last year, it was our first fully online program. And although it was well received, we candidly didn't think it would become a habit a year later. So things have really changed. Um, Indeed, I don't need to show you where the fire exits are anymore, or to ask you to set your mobile phones to stun for the Trekkies amongst you. But there is some housekeeping. We've allowed an hour for this topic. We have a presentation first, and we'll be picking up some questions at the end. Please feel free to send your questions through during the presentation using the Q&A button at the bottom of your screen, and I will try and marshal the questions accordingly to pick up at the end. The webinar is being recorded, and we will share the link with everyone after the event if you want to review it or pass it on to your colleagues. At the end of the webinar, we will be asking for some feedback in the usual way, and Kieran Laird's pay is entirely dependent on how well he does on his feedback. And very exciting, we're looking forward to the possibility of that we might be physically back in the autumn office. And so I'm not sure, to be honest, but I'm hoping we might be running a quick poll on how many of you would be likely to attend a physical event when it's all over. Some things, however, remain the same, and we certainly aim to deliver our loyal audience high quality speakers such as Kieran, covering a mixed diet of regular catch-ups and interesting topical subjects that we think will impact your day to day and are useful in providing a wider context on significant legal trends. And in that vein, today's topic is human rights and their relevance to companies. Ever since the concepts of incorporation and separate legal personality were established, questions have been asked on whether other aspects of personality are attached. Is the company made of unalloyed capitalism focused purely on profit and shareholder value? Or do they have a moral streak with duties to the societies in which they live, to employees, to contractors' employees, to those affected by their operations, and even to the environment? Can the veil of limited liability be used to hide themselves from wider obligations? And do directors have duties deeper than shareholder value? In the 1930s, after the Wall Street crash, these issues played out in the famous Burl-Dodd academic debate between the architect of the New Deal and the Harvard law professor. These days, the issues present themselves more in newspaper headlines, judging on rapacious director shareholder behavior and reputation destroying cost saving. And social mores are creating a more nuanced view on shareholder value and indeed, perhaps, shareholder values. To help explain the context of this corporate environment and address some of the issues it raises, I'm delighted to be joined today by our own human rights champion and partner in our public regulation team, Kieran Laird, who is working with an increasing number of clients to establish their good governance in this area. Kieran.
Thanks, Michael. Morning, everyone. Let's hope the person across the road from me has finished mowing their lawn, or I'm going to get some terrible feedback, and it's going to be a lean year next year. So, anyway, as Michael says, my job today is to give you quite a high-level introduction to the area of business and human rights, and there is a lot to cover. So we'll start off just with a bit of an introduction about why businesses are beginning to take this kind of stuff seriously. where relevant human rights come from, and where risks arise for businesses in this area. We'll then come on to talk a little bit about where the obligations in this area come from, both in soft law and hard law, and I'll explain those concepts whenever we come on to them. We'll then round off at the end with a couple of action points. Now, the aim today isn't to talk about the rights of companies themselves, because of course, as Michael did say, companies do have legal personality, so they do have some rights themselves. But what we're going to discuss today is how the actions of companies can impact on the rights of others. Now, whenever we think about human rights, we tend to think about the obligations and the actions of states. And it can be a little odd sometimes to think about businesses having obligations in this space. But it's not so odd whenever you begin to think about the power that companies have in the modern world in relation to the communities that they operate in, their employees, the people who they sell their goods and services to. Whenever you think about the impact and the debates around social media, you get a good handle on how these debates are increasing. And of course, then you add in the complexity of modern supply chains, where a company in the UK just selling to customers in the UK could be sourcing stuff from all around the world, from countries that have very little human rights protections. So whenever you take those two things together, the increased power of companies at the moment and the complexity of global supply chains, you begin to see a reevaluation of what we expect from businesses in terms of their corporate ethics. And the one way in which this comes to be conceptualized is the idea of a business's social responsibility. Now, you'll see what Milton Friedman says about social responsibility. He says that a business has only one, and that's to increase its profits, so long as it stays within the tramlines of fraud legislation and competition law. But over the last few decades, we've seen a more expansive view develop about the social responsibility of business and about what we expect in terms of business compliance with human rights principles. So it used to be that businesses sort of asked, well, where's my obligation to comply with human rights principles? But these days, you're seeing more of an acceptance that human rights issues are important, and we'll come on to that in a second. And the question is now framed in terms of, well, given that this is important, what do we do about it? What will it cost, and who do we work with? So, why are businesses beginning to take this kind of stuff seriously? Well, there are a number of kind of positive and negative factors. And before we get on to where any hard-edged obligations lie, I think it's important to realize that there is an actual business case for taking human rights seriously. This stuff can impact the bottom line. Let's start by thinking about investors. So, asset managers are increasingly offering investment funds with human rights criteria. We're seeing, for example, the Dow Jones Sustainability Index, the FTSE4Good, including human rights criteria. We're also seeing institutional investors like pension funds um, taking into account human rights issues. And more importantly, we're seeing those sorts of funds actually dump investments whenever whenever human rights problems arise or whenever companies don't meet their human rights obligations. If you think back to the end of last year, for example, we saw Scottish Widows dump £440 million worth of investments in companies that didn't meet their wider environmental, social, and governance criteria, their ESG criteria. And, and, and those included some elements of human rights principles. And whenever problems arise in this area, it can also affect a company's share price. So again, last year, I mean, we saw half of Boohoo's share value wiped out in 9 days whenever concerns hit the media about its working practices. And one of the other things that we saw happen to Boohoo was that its business customers started withdrawing from their contracts, and individual consumers started boycotting the company. So, I mean, you're also seeing both business and individual customers starting to take human rights considerations into account in their purchasing decisions. And we'll come on a little later to talk about the fact that there is an increasing wealth of data out there for investors, for consumers, whenever they are trying to evaluate a company's performance in this area. But of course, even before investors or consumers go and start digging into a company, whenever things go wrong and issues hit the headlines, that can have a very immediate effect on the bottom line. Governments too are increasingly expecting companies to act in accordance with human rights principles. One of the best examples of that is the Dutch government, which requires companies that it deals with to act in line with a series of specified human rights principles. And we're only going to see that increase around the world. Companies too are beginning to see the increased importance of their social license to operate. And by that I mean the level of approval or acceptance of a company and its operations in the communities in which it operates and from its stakeholders. And you can really see costs begin to increase whenever a company loses that kind of approval. You can see sales fall off, you can see workforce issues, protests, etc. So lots of companies are beginning to see their social license to operate as being as important sometimes as any regulatory permission that they might need to do business. Corporate ethics are also increasingly important. As a draw for potential employees. And these are people who want to see their own values reflected not just in what they buy, but also in the companies that they work for. So, taking all that kind of stuff together, there is actually a business case for taking human rights seriously. And we're seeing this kind of stuff move out of CSR departments and onto companies' board level radars as an actual governance risk. So whenever we talk about human rights, where do these rights actually come from? Well, there are two main sources of human rights in international law. The first is the International Bill of Rights, and the second is the International Labour Organization's Fundamental Principles and Rights at Work. Let's take the first of those, the International Bill of Rights. Now, that is made up of three separate components. The first is the 1948 Universal Declaration of Human Rights, and that contains 30 substantive rights, things like the right to freedom from torture, freedom of speech, the protection of family privacy and home life, for example. Now, the Universal Declaration is just an aspirational statement. It doesn't actually have any binding obligations. So, what you have in the International Bill of Rights are two covenants: the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social and Cultural Rights. And between the two of these, what they do is to take all of the rights in the Universal Declaration, apart from the right to property, and to make them legally binding on signatory states. There are also other human rights treaties that are of relevance. So you have treaties that address particular issues, for example, anti-discrimination or anti-slavery, and you also have treaties that address the rights of particular groups, such as women or children or migrant workers. The second element of international human rights law is the International Labour Organization's Fundamental Principles and Rights at Work. And that requires signatories to promote things like freedom of association, freedom of collective bargaining, the um, uh, the elimination of forced labor, elimination of discrimination in employment and occupations. Now, these sorts of international human rights treaties, international human rights instruments, aren't actually directly binding on companies themselves. But what they do is they put an obligation on states to regulate companies in such a way as to protect human rights, in order to make sure that the state complies with its obligations to protect rights. So that's where the rights come from. But how are these sorts of rights actually relevant in a business context? Well, I've put some examples on the slide here, and I'm not going to go through them all. But you can kind of understand, for example, how the supply of certain technologies that could be used for harm could breach the right to freedom from torture, cruel, or inhumane treatment. You could see how pollution can lead to effects on the right to mental and physical health. You can see how the right of protection for children can be breached by inappropriate advertising and marketing to children. And you can also see how companies involved in the life sciences, for example, need to pay particular attention to the concept of biopiracy. Now, that sounds quite exciting, but what it actually means is where traditional or indigenous knowledge about the nutritional or medicinal properties of a particular plant or of natural genetic resources are appropriated and commercialized without appropriate acknowledgement or compensation. So you can see how lots of the rights in international human rights law can be relevant in a business context. But where do risks then crystallize in relation to the breach of those sorts of rights? Well, it very much depends on how a company does business. So, for example, certain risks can arise from a company's business model, where, for example, a company is bringing cheap products to market with narrow product margins, where it relies on being the first to market in a very sort of competitive environment, or where it has a very seasonal business model. You can see sometimes suppliers being incentivized to pay low wages, to require excessive overtime, or to cut corners on safety in order to expand what can be quite tight margins. Who a company does business with can also be relevant. So there can be risks, for example, where a company enters into a joint venture with a government or with another company that has a poor human rights record. And also where a company does business. So you can see how there could be additional problems where a company is either operating in or getting or working with suppliers in a country that is quite corrupt, high levels of corruption or conflict, or poor human rights protections. Each particular sector will also have its own specific risks. So, for example, if you think for a moment about the extractive sector, they will have particular risks around sort of indigenous land rights, around environmental issues, treatment of workers and artisanal miners, for example. So too, there can be risks related to particular product and service lines, where, for example, a particular product could be utilized in order to cause harm. That will give rise to increased risk. So as I say, all of this taken together means that this is increasingly a board level issue. It's part of the overall governance risk framework for a company. So lots of companies are thinking to themselves, okay, so we need to do something, but what should we do? Well, at the moment, there isn't an awful lot of guidance to be gained from hard law. And what I mean by that is there aren't an awful lot of legal obligations that can be enforced in court. Now, that is changing, as we'll see in the next section. There are an increasing number of legal obligations. And those legal obligations are drawing on a body of soft law that has developed since the 1990s. And what I mean whenever I talk about soft law is a series of sort of agreements, principles, codes of conduct that companies have voluntarily signed up to. They can't be enforced in court, but which are voluntarily signed up to because of all the reasons we've just looked at. And what that body of soft law has done is to allow the idea that business should have human rights responsibility to permeate through society. And it's also created a body of concepts that various jurisdictions are now drawing on, as we'll see, in order to put in place hard-edged legal obligations. Now, the most important of those soft law frameworks is the UN Guiding Principles on Business and Human Rights. Now, these came out of a previous failed attempt by the UN to negotiate a legally binding treaty on business and human rights. Now, as we'll see a little later on, the UN is having another go at that. But at the moment, we have the guiding principles. So they were adopted back in 2011, and the idea is that they apply to all business enterprises, no matter what size the business is, where it does business, either within one country or across borders, so multinationally, and whether the business is either owned privately or by the state. And the guiding principles are organized in the tripartite framework, the protect, respect, and remedy framework. The first pillar of that is about the state's duty to protect human rights. So this is just an acknowledgement that under existing international human rights law, states have a duty to protect against human rights breaches by all actors, including businesses. So whereas states have a duty to protect human rights, under the guiding principles, there is the idea of companies' duty to respect human rights. So the idea under the principles is that the company should avoid infringing human rights wherever and however they do business, and also address adverse human rights impacts with which they're involved. As we'll see a little later, the types of concepts that are being deployed in the guiding principles are then being repeated in various other instruments, so they are quite important. And the principles then talk about the way in which a company should unpack its duty to respect rights. So first of all, the company should have a policy commitment to respect rights. It should then engage in ongoing due diligence, and that's to sort of identify, understand, and deal with and account for any human rights impacts, both in its own business operations, but also importantly, in the operations of businesses with which it has a business relationship. So, for example, its suppliers and its subcontractors. And thirdly, businesses should put in place remediation mechanisms. So, a way to deal with any adverse human rights impacts that they either cause themselves or that they contribute to through their business relationships. And that then is reflected in the third pillar of the guiding principles, which talk about access to an effective remedy. And the idea here is that remedies for human rights abuses and impacts should be transparent, should be accessible, and should give rise to predictable consequences. They shouldn't be expensive or corrupt or inaccessible. And at state level, the guiding principles talk about governments not just sort of fortifying their court procedures, but also putting in place non-judicial grievance mechanisms. And we'll see how some countries do that in just a moment. And then on the company side, the idea, as we've seen, is that companies should either put in place or participate in an effective grievance mechanism for any human rights impacts with which they're involved. A second important framework in the soft law space is the OECD guidelines for multinational enterprises. Now, the eagle eyed amongst you will immediately see that this is a narrower focus than the guiding principles. Whereas the guiding principles apply to all companies, the OECD guidelines just apply to multinationals. Now, they predate the guiding principles. They were adopted in 1976, but it's only relatively recently that they've started talking about human rights. So they were revised in 2011 to include a chapter which aligns with the UN guiding principles. And what they do is they set out principles and standards for responsible business conduct for multinationals operating in and from countries that adhere to the OECD Declaration on International Investment in Multinational Enterprises. That includes all 36 OECD countries, including the UK, as well as 12 others. And the OECD guidelines cover a lot of the same ground as the guiding principles. In particular, they talk about companies undertaking risk-based due diligence to understand and to deal with any human rights impacts, either actual or potential, that they might give rise to. What's most interesting, though, I think, in the OECD guidelines is the idea that they require each signatory country to set up what's called a national contact point, or NCP. And the NCP is there to investigate complaints about a company operating in or headquartered in that country. So you can see how it's one of the ways in which a state tries to comply with the idea and the guiding principles that it should put in place non-judicial grievance mechanisms. And how countries do that varies pretty widely. So some are based in government departments, and some are more independent bodies, which can draw on sort of NGOs or government officials or trade unions, for example. Here in the UK, the National Contact Point operates out of the Department for International Trade. It doesn't have ministers or whatever sitting on it, but it's housed in the department. And that's actually one of the most active national contact points around the world. It gets a couple of complaints a year, pretty much all of which deal with alleged breaches of the human rights chapter in the guidelines. What it does is it looks to see whether a complaint will fall within its jurisdiction. It then tries to get the parties to mediate, and if mediation doesn't work, it then puts out a non-binding determination and makes recommendations in terms of any breach that it finds. So what's interesting about the national contact points is that even though they're based at national level, and even though the OECD guidelines aren't adopted by every country in the world, the national contact points at the moment are pretty much the only international mechanism for holding companies to account for human rights breaches. Now, the UN Guiding Principles and the OECD guidelines are set at a general level. They apply to all companies. So each individual company then has to try and figure out what that might mean for its own business. And so what you've seen over the past few years is a development, a sort of burgeoning of private and semi-private regulation in this area. At its most basic form, it takes you have company level policies and codes of conduct. And this is where, for example, a company tries to adhere to the UN guiding principles by putting out a policy on human rights compliance. Now, as you would expect, these sorts of policies differ widely in terms of what they cover and how they do it. But there are some general sort of criticisms leveled at them in terms of lots of them don't involve stakeholders whenever they're being developed, and some don't have independent or transparent monitoring or reporting mechanisms. You also see companies getting together at sector level to try and unpack the salient risks for each individual sector and to try and share best practice about how to address those risks. And that can be quite useful because it can help companies spread the cost of trying to unpack some of this stuff. And it can also serve to set a common benchmark or standard to kind of level the playing field in terms of what's expected from companies in a certain sector. So whereas companies band together themselves for that type of stuff, you also have some multi-stakeholder initiatives where companies also band together with other actors like governments or NGOs in order to try and set some voluntary standards. A different kind of thing then are certification schemes. And this is where an independent body assesses a company or a product against certain criteria, for example, compliance with certain human rights issues. And then if it meets those criteria, the body will give the company or the product a kind of stamp of approval. So think here about things like the Fair Trade Scheme, or in terms of jewelry, the Kimberley Process Certification Scheme that tries to eradicate the trade in blood or conflict diamonds that fund violent militias around the world. And lastly, in this section, I talked a little earlier about the fact that there's lots of information and data out there for investors and consumers. And part of the reason for that is a growth of indices and benchmarks in relation to human rights compliance. And this is where third parties rank and compare companies against human rights criteria. Now, usually that kind of data, the data on which these things draw, is self-reported, and that means that in some ways they come in for some criticism, but it can also mean that it's important for companies to actually sort of engage with these sorts of processes, because a company can sort of define its own narrative to a certain extent. And you see these indices and benchmarks both at the sort of general level. So the corporate human rights benchmark is the most famous, as well as sort of industry specific levels. So things like the Fashion Transparency Index. So all of that soft law, as I say, has created a situation in which the idea that businesses have human rights responsibilities isn't beyond the pale anymore. And if you spoke to lots of people on the street, they would kind of agree with it. And it's also created this set of concepts that are increasingly being wired into hard law obligations. So let's look at some of those obligations. Let's start at home. So whenever I was talking about what the relevant rights might be, some people might have thought to themselves, well, actually, some of that's actually just reflected in general law, isn't it? And it is important to recognize that governments around the world have been regulating areas that relate to business and human rights for decades, long before the concept of business and human rights was first coined. So, for example, in the UK, you will see the ILO's fundamental principles and rights at work being reflected in employment law, and you'll see various other human rights issues being reflected in things like data protection, health and safety law, for example. Now, there are more specific human rights and business laws in the UK. So, for example, the Human Rights Act 1998, it requires companies that perform a public function to adhere to to the European Convention on Human Rights whenever they're performing that function. The idea there is that whenever a company steps in to the role of the state and undertakes some of the functions of the state, it should have the same obligations as the state in international human rights law in terms of protecting human rights. Now, of course, the Human Rights Act will only apply to a minority of companies. Of wider application is Section 172 of the Companies Act, and that's the section that talks about directors' duties. So if you remember back, what that says is that a director must act in the way that he or she considers is most likely to promote the success of the business for the benefit of its shareholders. So good old capitalism. However, in doing so, he or she must have regard to the impact of the business on the community and on the environment, and also have regard to the desirability of maintaining a reputation of high standards of business conduct. So you can see how that can actually bring in human rights concerns. Now, people's first reaction to that is generally, well, that's just a have regard to duty. That's quite a woolly thing. You know, no one's ever going to be held to account against that. But there was a case a couple of years ago, and Antuses and Houghton, in which company directors were actually found to be in breach of Section 172 in relation to human rights issues. And this was a case where the company directors had knowingly and willingly allowed employees to be paid below minimum wage and to be treated with in absolutely horrendous conditions. And what the court said there was that these conditions, which pretty much amounted to modern slavery, were so abhorrent to the community that by allowing this to take place, the directors had pretty much trashed the company's reputation. It had damaged the business to such an extent that it must be a breach of Section 172, as well as breaches of sort of employment contracts, and as well as this company losing its gang master's license to employ immigrant workers. So even though that duty can seem a little vague, it is important to realise that directors can be held to account against it in the area of human rights. There are also reporting obligations in UK law. And sticking with the Companies Act again for a moment. So, for example, Section 414C requires certain companies, certain large companies, to put out a strategic report. And part of that report is to outline whether the company has a human rights policy and how effective it is. We also have the Modern Slavery Act, which lots will be familiar with. And that requires companies with an annual turnover of 36 million or more to put out a report each year detailing what steps they have taken in the last year to make sure that there is no forced labor or slavery either in their own operations but also in the operations of their supply chain. Now, of course, and we've seen the Modern Slavery Act We've seen proposals to toughen up the Modern Slavery Act at the end of last year. Now, of course, it is just a reporting duty, so a company can't say, well, I've taken no action whatsoever, and I would still comply with the law. But from a government's perspective, these sorts of reporting obligations are a way of requiring companies to begin to audit and understand their human rights impacts, and also to provide data against which a company can be held to account in the market. So, for example, the idea is that a company's consumers may not be too happy if it says, well, I've taken no steps to address modern slavery. Those sorts of reporting obligations can also be a way of getting companies used to and familiar with human rights concepts, and that then provides a basis on which governments can impose more onerous human rights duties. And we're seeing that at the moment in the EU, and we'll talk about that in just a second. However, staying close to home for just a moment longer, of course, statute law isn't the only source of law we have in the UK. We've got the good old common law. And over the past few years, we're seeing an increasing number of cases in which companies are being sued in tort in the UK on the basis of human rights abuses overseas. And this is usually at the moment where a parent company is being sued because of the actions of its subsidiary abroad. Now, these sorts of cases are generally taken as personal injury or damage to property cases, so they don't cover all of the relevant human rights, but they are nonetheless critically important. So let's just take the example of Vedanta, which was a case from 2019. So what you had here is a group of Zambian individuals who brought claims in the English courts against the Zambian owner of a mine and its UK parent company in relation to toxic emissions by the mine from the mine in Zambia. So of course, as you can understand, the first reaction of the UK parent company was to say, well, this isn't about us. We have no duty of care here. So the Supreme Court then had to look at whether or not the claim was properly brought against the UK parent. And what they did was to reiterate the test that what you do is you look to see whether there is a real issue to be tried against a UK parent company. And if there is, that parent company can then act as what's called an anchor defendant. And you can also bring in a co-defendant from outside the jurisdiction, in this case, the Zambian mine owner. So in these cases, what the court does is to look at whether there is an arguable case that the UK parent company owes a duty of care to people affected by its foreign subsidiary. And the Supreme Court was reluctant to set out any hard and fast test at this point. But from our perspective, what's interesting is that it did say that a duty of care on the parent company is likely to arise where the parent holds itself out as exercising supervision and control, even where it doesn't do so. So if you say that you control your subsids, you could be under a duty of care. And also where the parent company takes active steps to make sure that the subsidiaries implement a group level policy. And what's really interesting is that the Supreme Court said that the same principles could apply to policy or public statements about business relationships with third parties. So that could mean that where you say that you control your suppliers, you could also have a duty of care in relation to people affected by their actions. And that approach was affirmed just very recently in the last couple of weeks by the Supreme Court in another case, Okpabi and Shell. And so what you have in these cases is companies being held to account, basically creating a duty of care for themselves by the policies that they implement. And you think to yourself, well, is this going to have a chilling effect? Are companies going to say to themselves, well, listen, I'm not going to create a rod for my own back here. I'm not going to have a policy that says that I will take anything to do with what my subsidiaries do in this area. But that's a little short-sighted because obviously, whenever we get to the point in the main hearing in these cases of seeing whether or not there has actually been any breaches by the subsidiaries, of course, the parent company is going to want to know about that, because if there have been sort of actions that shouldn't have been undertaken by the subsidiaries, the parent company needs to know that and needs to deal with it for all of the reasons that we looked at in the first part of the presentation. So what this does is it shows the importance of human rights due diligence. And what we're increasingly seeing is jurisdictions around the world bringing in obligations, legal obligations to conduct mandatory human rights due diligence. So France has had this since 2017, the duty of vigilance law. At the beginning of this month, we saw Germany adopt a draft law requiring companies of a certain size to undertake mandatory human rights due diligence through their supply chains and to put in place complaints mechanisms. Switzerland and Norway are going to enact similar legislation this year, and Denmark and Finland also have legislation on the stocks. And against that background, we're also seeing action at the EU level in the form of a draft directive that will require mandatory human rights due diligence. Now, at the moment, the idea is that directive would apply to large undertakings. Now that's not defined, but it might be the same sorts of companies that are covered by the non-financial reporting directive. It'll apply to publicly listed small and medium enterprises and SMEs operating in high-risk sectors. Now, high-risk sectors isn't defined, but the idea is that the European Commission will put out a list. Now, what's important to realize is that it's not just companies falling within those categories that are established in the EU that will be affected. It'll also be companies that sell into the EU. So where a company falls within those categories and it's a UK company selling into the EU, it'll be affected. And so what are the obligations? Well, some of these will look familiar. States will require companies to undertake mandatory human rights due diligence, as well as wider due diligence in relation to environmental and governance risks, in order to understand and to deal with any risks posed by their own operations or those with whom they've got business relationships. They will also be required to put in place robust complaints mechanisms and to make sure that stakeholders, a wide variety of stakeholders, are involved at every point in the process. States are also going to be required to enforce these obligations. Now, what's really interesting is that in one of the earlier drafts of this directive, the Commission had floated the possibility that repeated infringement should be a criminal offence. Now they've backed away from that in the draft that we have at the moment. So there'll only be civil penalties, for example, fines. But what's really interesting is that the current draft would allow claimants, individual claimants, to bring civil cases against companies for harms caused in overseas value chains. And that might mean, if this is enacted in the way it's framed at the moment, that a UK company that's caught by the directive selling into the EU could be sued by an individual in the EU on the basis of actions by a supplier overseas. So quite an important thing to keep an eye on this draft directive. The European Commission has a draft. It's going to introduce it into the European Parliament's legislative process with the idea of trying to get it on the books by the end of this year. Of course, because it's a directive, individual member states will then need to implement it in their own domestic legal frameworks. So we're going to see a year or two before this actually bites. On a slightly longer finger and on a slightly higher level, the UN is also having another go at negotiating a legally binding treaty in this area. As I've said before, the UN has had a couple of attempts at this and hasn't been successful so far. Now, this current attempt kicked off in 2014, and what we have is a draft that was released in August last year. And the draft treaty would apply to all business activities conducted by all business enterprises. So corporations acting just within one state, multinationals, privately owned enterprises, state-owned companies, for example. And no matter what the turnover. And again, some of this stuff will look familiar. It just draws again on those ideas that we saw in the UN guiding principles. So the states that sign up to this treaty would be required to get all businesses within their territory to undertake proportionate due diligence, so proportionate to the size and to the risk profile of the company, in order to identify, understand, and deal with any actual or potential human rights abuses. And again, that's in their own operations or in the operations of their supply chain, to monitor effectiveness and to communicate regularly with stakeholders. And the draft treaty outlines a little bit about what this due diligence would include. So it would be things like impact assessments, engaging with stakeholders, non-financial reporting, taking into account gender perspectives, flowing obligations down in contracts, and undertaking enhanced due diligence in high-risk areas. And again, there would be enforcement. So states would be required to provide criminal or civil sanctions against companies or individuals within those companies who have caused or contributed to human rights abuses. Now, as I say, this has been on the card since 2014, and as with anything in the UN, it doesn't get anywhere fast. We'll have to see whether over the next few years it's actually adopted as a treaty, and then of course which countries sign up to it. So I think it's clear that there are legal obligations coming down the track. I mean, this stuff is only going in one direction. But of course, I would hope that it's also clear that even before or where there aren't legal obligations, there's a very good business case for taking human rights seriously in a business context. And as I say, we are increasingly seeing human rights issues making it onto board level radar in terms of an overall package of governance risks. So where would a company start? Well, it's important to get board level buy-in. I think this stuff only really works if it's led from the top. And then it is a question of just trying to identify and understand where your particular human rights risks lie, and then considering what can be done to remove or mitigate any risks that you identify. And it can be important to put in place complaints and whistleblowing processes. And the reason for that is that it's always good for a company to be able to identify quickly any emerging issues before they either hit the press or hit the courts. And do look at some of the sector level initiatives that are out there. There's a lot of really valuable learning that companies can draw on. And of course, here at Garland, we're always happy to help with these issues. We've got a great team here in the UK, in Canada, in our other offices across all of the different areas that this stuff touches upon. And we're more than willing to help companies whenever they're thinking about policies or grievance mechanisms, or God forbid, whenever a complaint is brought against them. So I hope you've found that useful. I see that there are a couple of questions already. And thank you very much.
Thank you. Thank you very much, Kieran. That's a fascinating skip through some very interesting issues there, and at a level, I have to say, which is engaging and beyond the day to day, and clearly a strategic issue. As you say, we've got a few questions come through, and I think if I probably can take them in order, and forgive me if I'm going to be using people's Zoom tag name, so forgive me if I get the name wrong, but I'll just be using what I can see. First question, Kieran, from Elizabeth is what you've observed in relation to competition and economic regulators in terms of how they are incorporating those human right principles into their regulatory standards or their approach to enforcement.
Well, you do see you do see this to an increasing extent. I mean, what's interesting is that lots of these sorts of regulators won't necessarily couch these sorts of things in human rights terms. But for example, whenever you see, just talking about economic regulators, and whenever you see Ofgem, for example, putting in place protections for particular vulnerable customers, in terms of how companies seek to recover debts, whenever you see Ofwat putting in place, I think it's in statute, the idea that you shouldn't actually cut off someone's water for failure to pay bills. That's obviously to maintain sort of access to water as a basic right. What's really interesting is where Ofcom is going to start going in this space, because of course one of the things that Ofcom is going to have to deal with over the next few years is people's increasing attention to things like social media, to the way in which data gets used, where companies harvest data and then sort of use that, to the way that AI gets deployed and how that can breach human rights in some areas. And of course, at an overall level, we're also going to see something like the Center for Data Ethics and Innovation coming in to try and address some of those, how human rights plays out in some of these very new frontiers. So lots of interesting stuff happening.
Yes, and I think there's I'm not a corporate lawyer, but I think from recollection, sometime after the company law review a few years back, the takeover code got amended a bit to allow businesses to, or certainly directors, to take more than just the price of a particular offer into account. And I think that was largely off this nuanced view of in shareholder value being more than just money, but including things like reputation and goodwill and standing, if I can put it that way.
Yeah, and that, I mean,
sorry, Kevin.
No, sorry. I'll let you ask the next question. I could prattle on for ages on this. Go ahead.
Okay, well, we might come back to it. So we've got a couple of questions then from Anja, which is around, I think, the Lungoy decision and the status of those companies that share common directors. And I think Lungoy was a bit more around statements in glossy accounts around its highfalutin standards and that kind of thing. But obviously, very often there are closer links, parent and subsidiary sharing common directors. So I think there's a question there about the extent to which that can establish the correct link. And then a related question from Anja is around how do you go about establishing losses in terms of parent when the losses are felt in a jurisdiction a long way away, in relation to activities carried on by a subsidiary a long way away.
Okay, well, we'll just taking the first of those first. I mean, there's not an awful lot I can say about this, because the way in which liability is established will always depend on the particular sort of company structure that's in place. And in particular, whether or not sort of directors' duties bite will depend on sort of where those duties lie in relation to whatever entities the director owes the duties to. What's interesting about establishing liability and losses is that in the cases that we have at the moment, so Vedanta and the Shell case, we've only really got to the point of establishing the preliminary point that you can go against the UK parent company for the actions of a subsidiary. We haven't actually seen any cases yet that have come to conclusion where we will see how the court addresses how do you unpack sort of losses and things like that. But one thing I will say about that is that you are seeing some companies that are just seeking to settle this kind of stuff fairly quickly. So, for example, at the end of last year, Camellia, UK parent company, which sells avocados to Tesco, there was a case launched against it in the UK High Court by I think it was a group of 79 Kenyan individuals about alleged human rights abuses, some quite stark stuff happening allegedly in an orchard in Kenya. And Camellia settled that in February for £41 million. So we haven't seen that get to court, but that's an indication of the type of things that the companies are settling for. You're also trying to see some companies, whenever this stuff kicks off, trying to get ahead of the issue. So so I think it was, is it Petra Diamonds? There was a case launched against Petra Diamonds in about September of last year as well. Petra Diamonds are famous because they sold the Queen. They either sold or gave to the Queen the lovely big sort of pink diamond. flawless pink diamond that she has. So this obviously hit the media, and Petra have tried to really get out in front of this issue before it gets any traction at court, and have sort of put in place lots of investigations, and have been very sort of astute in trying to sort of report actions that they've taken, hopefully with the idea that they won't get to a point where there's any finding of loss or liability.
That's one of the advantages of open systems of justice, where you've got a social zeitgeist which is holding companies to account for their behavioral standards, not just their financial performance. That willingness to settle obviously becomes an important factor, because you don't want even the publicity of a bad case. Even if you win, you can still win bad cases and not have the right result, can you?
Well, there's two things there, Michael.
Mm.
So I mean, just in the Camellia case, I mean, whenever you talk about the effect of this stuff, as soon as that case was put in, was lodged to court, before there was any finding, even about jurisdiction, Tesco immediately cancelled the contracts. So as far as I was concerned, just the sniff that there might be an issue here was sufficient from its reputational perspective, which is to say, okay, we want nothing to do with this. And the way the companies handle this can be quite important, because you can think about the comparison between the fact that whenever Boohoo encountered issues, half of its share price gets lost in 9 days. Amazon cancels contracts, such like. Whenever you think about H&M, by contrast, if you remember, there was we've just seen this morning actually that that lots of people in China are sort of pushing back against H&M's. Not well, they're boycotting H&M because H&M is saying it's no longer sourcing cotton from certain areas in China, and that's because of H&M's reaction to issues that were drawn to its attention in relation to forced labour in cotton and packaging. But whenever those issues first came out, they didn't affect H&M's share price. Now, part of the reason for that is that H&M actually has a really good reputation in this area. They're seen as kind of sort of market leaders in business and human rights and in fashion retail. So they were able to sort of get on top of this very quickly.
Okay, we've probably got time for just one last question, and then we will wrap it up, I think. Longori and Opkapi were, I think, as you rightly pointed out, forum cases, forum non-convenience cases. And so we've yet to get to what we might call the legal issues. But I think the trouble with that, of course, is those kind of cases have jurisdictional issues, don't they? Like things like, we won't hear it because we might have irreconcilable judgments, or there's courts already seized, so we won't do anything until we find out what's happening there. I mean, do you see there being a sort of international playoff of human rights, a kind of sort of human rights forum shopping situation arising there?
Well, it is certainly a danger. Now, Vedanta, one of the issues that arose in Vedanta was the application of EU jurisdictional rules in that case. Where one of the things that the claimants had to show was that there was no possibility of being able to take this case in the other jurisdiction, and the court accepted that there wasn't, but the court was very clear to say, we might see a change to jurisdictional rules such that if we do think it's appropriate for a case to be brought in the country in which the breach took place, then we will be happy to let the case proceed in that jurisdiction. In America, they had very broad jurisdictional rules, which just in the last year or two have been overturned by the Supreme Court. So it used to be the case in America, you could sue a business for any human rights breach anywhere in the world, but now they've restricted that jurisdictional element to it has to touch upon the US. But just the final point in that regard is it'll be really interesting to see this draft directive in the EU, and how that unfolds, because of course it has that ability for claimants in the EU to sue companies outside the EU in relation to actions of suppliers somewhere else in the world. So that is going to make forum shopping an awful lot easier, I think, where cases touch the EU.
Thank you very much, Kieran, and thank you to all of you for attending. For those of you who are still around, and I'm conscious we've gone a little bit over time, so I know people might be leaving. If you've got a bit of time, I'm hoping Susie's being able to set up our poll as to for those of you who would like to attend in person next time. So just if you could just have, before you disappear off, if you could just give us a quick click of the button there, that would be really helpful. Thank you. And whilst you're doing that, it's just up to me to say thank you to Susie for organising this so well, and for Kieran for such a really interesting and thoughtful presentation. Thank you very much, Kieran.
Thanks all for listening.